This is going to be yours. So today we're looking at legal documents and more. And so we have different formats, but today we opted that we want to have more or less a conversation with our legal expert here, Sarah Kendrick from Rainey & Rainey. But Sarah, would you introduce yourself a little bit about the role you play? Your firm focuses on elder law. Oh, I always say we're not here just to promote Rainey & Rainey. It'd be a good law firm for you to know about. But also she's representing the industry in terms of understanding, especially legal as it applies to seniors and our being prepared. So go ahead and introduce yourself.
Thank you, everyone, for having me. I am really happy to be here. So a little bit about Rainey & Rainey and elder law attorneys in general. Rainey & Rainey has been an office. We started in Waco, Texas. We've been around for 20 years. I work for a husband and wife, James and Elisa Rainey. Our office has 2 locations, one here in Georgetown, right off I-35 in Williams, and then one in Waco. We have 5 attorneys between the 2 offices, and our practice exclusively focuses on elder law, which includes probate, guardianship, estate planning, special needs planning, Medicaid planning for long-term care, and some VA planning as well. That is all our office does. We don't handle any other types of law. And I will say, I think a little bit to your point, if you are looking for an elder law attorney and you choose someone else, a great resource for that is going to be the NAELA website, which stands for National Academy of Elder Law Attorneys, so NAELA.org. And you can find elder law attorneys all over the U.S. using that website. If for some reason you have a loved one in another state or something like that, or you're just talking to a sibling or something like that and you're looking for someone in their location.
Okay, speaking of, let's go ahead and clarify about elder law attorneys. Now I know you've told me you are an attorney in an elder law focused firm, but elder law attorneys focus, what makes that different? Why is that important?
Sure. So the primary thing that's going to set aside maybe what you think of as an estate planner, so someone who just focuses on wills or trusts or powers of attorney, is going to be that Medicaid planning component and the special needs planning component. So oftentimes, there are a lot of law firms that do estate planning or general estate planning, but the focus is more towards how am I transferring wealth or assets at death. And our focus generally is a little bit more on how are you going to pay for long-term care if you should ever need nursing home care. And how are you going to be able to access public benefits to be able to pay for that care?
Well, now that just, we're going, long-term care, we will get there. We do have it on the list here. So, okay, so and we say things overlap, and that's fine. But the more you know about this and how you put pieces of the puzzle together to work for you is what we're really doing. Okay, we're going to go through, and I know we often hear discussions about, these are the 5 legal documents you need to have. Yes, but I also know a number of people, that's a step, if we get the legal documents, but what happens after that? Do we lock them away in a safety deposit box? That could be problematic, possibly. Do we not tell the person who's going to be the administrator, or, do they have a copy? So there are a lot of things we need to look at. It's not just the documents, but what do they do for us, and what do we need to do with them? So as we go through today, we're going to try to focus in on that. Let's start with wills. I know we've had a lot of questions from people about, primarily because so many people have moved here. They say, okay, my will was done out of state. Is it going to be valid in Texas? We know Texas thinks it's special, so, but will it, will it accept wills drawn up in other states? How often do I need to do my relook even at my will? So talk to us about wills.
Sure. So I think I'll touch on a couple things you sort of mentioned. I think first and foremost, when you do your estate planning documents, every probably 5 to 10 years, you should pull them out and look at them. Do they still make sense? Is the person you've named as your executor, have they passed away, or did they get dementia, or was it a friend who still lives in Colorado, but now you live in Texas, so it no longer makes sense to have that person named? So a lot can change. I always advise clients that anytime there's a big life event, someone gets married, someone gets divorced, new children are born, someone passes away, any of those things are going to be a reason why, does this change my own planning? And so every 5 to 10 years, you really should pull out all of the estate planning you've previously done and looked at it. Also, once you have your estate planning documents, so that's going to be the wills, the power of attorney, the medical power of attorney, directive to physicians, HIPAA authorizations, designation of agent for disposition of remains, right? There's lots of documents, and all of those are kind of collectively called estate planning documents. Once you have those drafted, I always recommend that at the very least, you should keep those in your home in a fireproof box or a fireproof bag. You should notify at least the first agent on that document. So for example, for my estate planning, if I have my mother named as my agent or I have her named as my executor, I need to let her know these documents are in the fireproof bag that I keep in the spare bedroom, in the safe, and you can find the combination to the safe in the garage in the nail jar. That way, when I have the accident at midnight and my mom shows up to the hospital to make medical decisions for me, she has the documents that she needs if I haven't already given her a copy. One step further, I would say, is that you really should, if these are trusted people that you have chosen to make decisions for you, they should have a full set of at least copies of these documents. Maybe you keep the originals in your home in your fireproof box, but a full set of copies should be with your first agent. So again, at 3 a.m., when the hospital is trying to track someone down, they already have those documents and there isn't a scramble to go find them. We absolutely do not recommend putting them in a safe deposit box. If you are going to put documents in a safe deposit box, you better put that agent on the safe deposit box as a joint owner and give them a key, because when they show up to the bank and they say, my mother passed away and I need to get the will and it's in the safe deposit box, the bank is going to say, bring me a court order and we'll open that box for you. And so it's really problematic if you put them in a safe deposit box and the person that's your agent or executor or trustee isn't also a joint owner on that box and they don't have a key to get into that box. So I think you also kind of wanted me to touch on wills. So if you remember nothing from this conversation, what I want you to remember is that for a will to be a valid document to transfer assets, it has to go through the probate process. So you cannot use a will to transfer any assets without it being probated. Truly, if you don't remember anything else, that is what I want you to take away from this. So often I get a call saying, my father did a will and it says everything goes to me. So can you just put the house in my name? I need to go to the bank and get all the money out of the bank account because I'm the beneficiary under the will. That is not how that works. So what a will does is it identifies who the beneficiaries are going to be. It identifies who we want our executor to be. It identifies how we want the executor to handle our estate. But the only way that an executor ever actually gets appointed is if we probate that will with the court. Probate in Texas is relatively straightforward. It's relatively inexpensive when you compare it to other states. But you must know that if we are transferring assets using a will, that document has to be probated. It is not just show up to the bank with a death certificate and a copy of the will, and they will turn over that bank account.
And that is so often misunderstood. Or I don't know, just not understood. I mean, you
Just
know.
not known.
We have and as a realtor, and I work with people, a spouse has passed away, I go in to talk with them, and, oh yeah, well, we have a will, it's all mine. Well, yeah, there's some steps, but we're also going to talk about ways
Around that.
I think you said probate in Texas is relatively easy. Poor probate. I mean, it just has a bad rap.
It does.
I mean, you hear and you just go in. But the good news is plan ahead, and you can. I don't know if you like for me to use the word avoid, but you can usually possibly avoid probate. Okay, one way that I'd like for us to start out with is discussing trust. Now, until I got into this, I just always thought that a trust was for someone, or couple, whoever, who had a lot of money, a business, a lot of money. So I thought, I don't need a trust. But a trust is more than that, I've come to understand. Tell us a little bit about trust.
So most people are familiar with the concept of a revocable trust or an irrevocable trust. I'm going to focus mostly on revocable trust and try to touch a little bit on irrevocable trust. But a revocable trust, the way I like to think about it is that the trust is actually creating roles for people, and I think of it like a bucket. So the trust creates this bucket, and it then creates the role for the people who can create the bucket. That's the grantor. That's the person who wants to set up the trust, all right? Then there's the trustee. The trustee is the person who has the power to put things into the bucket, take things out of the bucket. If they're in the bucket, they can manage the things in the bucket. And then there's the beneficiary. And the beneficiary is the person who the trustee can take the things out of the bucket and give to the beneficiary. So the grantor, the trustee, and the beneficiary often are all the same person. It's just a matter of how are you acting in that particular moment, all right? So a trust, the beauty of a trust is that if you create a trust and you start adding assets to this trust, then the trustee can pay bills while you're alive. The trustee can buy assets, sell assets, can decide a different way to invest assets, can distribute assets to you. So if you need $500 a month to pay your grocery bill, the trustee can do that. And then when you pass away, the trustee can also make sure your beneficiaries get whatever items were in the trust. Was it a house? Was it bank accounts, vehicles, stock accounts, life insurance proceeds? And the trustee can give those things to the beneficiaries without a need for probate, because all of the legal documentation is already in place to describe who has the power and who does this money or asset go to. And so to me, the biggest difference between a will and a trust, and really cost, is there's a little bit more cost on the front end, and there's a little bit more work on the front end with a trust. We create the trust, we retitle assets into the name of the trustee of the trust, and then we kind of let it run. Versus a will, it's a little less expensive to do it on the front end, but for the will to work, you then have to pay for probate after you pass away. So we don't know what that cost is going to be, right? Because do you die tomorrow? Do you die in 30 years, right? And so there is, in some ways, with the trust, a little bit more control over cost because it's a cost now. And then again, there is that work of making sure you go down to the bank and you say, okay, this says this account is owned by Sarah Kendrick. Now this account is owned by Sarah Kendrick, trustee of the Kendrick Family Trust.
And I just see that so much, how many, and also knowing what you do have. I've seen people where they're ready to, again, it's a situation where a spouse has passed away, and we meet with them and get ready to do the listing agreement, and at least for me, I'm saying, okay, we need to open title with the title company. We need to see whose name. Oh, well, it's my name, it's all mine. Okay, I'm sure it is, but let's just, and then sometimes we get surprises, or they don't tell us, well, no, we really do have a transfer and death deed, and we're going to get into some of those in a minute. But it's interesting what you said about cost, that yes, front end or later on. Now I'm going to ask a question. I didn't warn you about this one. So this is.
See if I can handle it.
Let's see. Yeah. Who can write these wills? I don't know about trust too. I was walking through an office supply store yesterday, and there's all that section of, do your own will and all. I mean, I can, okay, I'll say, when being fair to you about
Sure.
that, as a realtor, well, I'm just going to sell my home myself, just out by owner. You can do that. Here's some things I'd be aware of. So I don't mean to, but I got to save money. Okay, and maybe what do you weigh? So what about? Can I just write my own will and be done with it?
Yes.
Will it work?
Maybe. So there are, quite frankly, my advice to most people, if they're telling me, I can't afford to hire an attorney, sometimes it's, well, you probably can't afford not to, but I would rather someone do a fully handwritten, all in their own handwriting, signed and dated will than something they've pulled off the internet or something they picked up at Home Depot or Office Depot. I guess you're probably not getting wood and a will at the same time, huh?
Maybe.
So I would truly rather you take a piece of notebook paper and handwrite something out over using one of those wills. And the primary reason is because when you use some sort of typed up or fillable form, it matters that it's witnessed and signed properly and notarized properly. And I have seen wills fail because we didn't take the proper steps in the signing ceremony. So like in our office, for example, we have a very formal signing ceremony. You get sworn in, you're asked if you're over a certain age, you're asked if you want the witnesses to witness for you, you're asked if you understand that this is your last will and testament, we're asked if anyone's forcing you to sign this will. Everybody signs. Then we ask witnesses question. Are you over 14 years of age? Have you signed this in their presence? Did they ask you to sign this will? So we have a very formal signing ceremony because that is oftentimes where a will fail, is that it was not witnessed, it wasn't signed properly, and it creates problems. So people have what they think is a valid will, and it turns out not to be a valid will. And now we're doing an heirship proceeding, which is much more expensive than probating a will, and it's much more time consuming. And that was kind of what you were trying to avoid on the front end anyway.
And the point is, sometimes I think, why do I have to go through this rigmarole, this formal, signing? Just let me write it and be done with it. In this day and time, folks, transparency is so absolutely important. And if any of you are following the news, you see that's the issue behind the stuff in real estate. We'll talk about that in July. But transparency, documentation is critical. And having that official support. I was called in to help a friend I knew the mother too. I think she had a will not done by an attorney, done somewhere. And so then they were trying to piece together so I could be a witness that I knew the mother when she was alive. And, just you pay up front or pay later.
Mm-hmm. Absolutely.
So, okay, so now you talked about revocable. Did you want to quickly mention irrevocable?
So typically an irrevocable trust is really just what it sounds like. You create a document, you transfer assets to it, and then those documents can't really be changed. There are reasons you do an irrevocable trust. Oftentimes, if we use them for Medicaid planning, for some long-term planning so that you can get long-term care. But typically, that's not the kind of trust that most people are using, and it's also not a last-minute trust. So an irrevocable trust is usually used for very long-term planning. I'm healthy, I'm not anticipating needing any sort of care. I kind of maybe think I have more money than I need to live out my life the way I want to.
That would be nice.
And so I'm moving some, but probably not all my assets into this irrevocable trust. But you really do have to think about it as you no longer have access to those assets in most cases.
So most often, but again, go back to my original statement about wills and trusts. And this really helps us understand what the trust does. And even though I don't have tons of money, can I still do a trust?
Absolutely.
If I pay you to do it?
I think the biggest reason to kind of should I do just a will or a trust is, are you going to take the steps to make sure your assets are a part of the trust? I can charge you all day long to create a trust, but if you don't go down to the bank and change how your assets are or your cash accounts are owned, you're going to have spent a lot of money with me creating this document that really doesn't control anything. So a trust is a really great option if you're going to take the steps. So kind of your action plan. If you're going to follow your action plan, a trust is a great option. If you're going to say, oh, I have this pretty paper now, I'll go
check it
off and not do those next steps, I'd rather you just have a will.
Okay. So, and some people get concerned, like on real estate, when you see, we have to go through all that trustee. Okay, we do it. It's okay. Just, it means more writing or more typing in a trustee of the da-da-da-da estate. But if we've moved along smoothly, it's invaluable. So, okay. I'm sure there are questions. We'll come back to some more of those. But I want to, and this may have been even a more basic question, but let's talk briefly about power of attorney.
Sure.
What power of attorney means, who should I select, does it have to be my oldest child? And talk to us about power of attorney.
So typically, there's kind of two main powers of attorney. There's a durable power of attorney, so think all your financial matters or the business of you. And then there's medical powers of attorney. So think making medical decisions. And we'll talk about both. So first and foremost, with a durable power of attorney, you give a lot of power. Even a very basic, I picked it up at Office Depot and signed it, you give a lot of power in that document. And so you really need to choose someone who you trust to act in your best interest, because they will have full access to financial accounts, real estate transactions, stocks, bonds, helping with life insurance. And so it's really important that you choose someone who is a little bit business savvy, right? They handle their own finances well. They know how to handle finances. They're willing to sit on the phone and deal with the life insurance customer service for hours on end. Those kinds of things are important when you're choosing someone. So oftentimes, yes, I get people who are like, well, I'm going to name George first. He's my oldest, and I'm going to name Bob. But meanwhile, George is a farmer and doesn't handle any of his finances. His wife handles them. And Bob is a CPA. So maybe that doesn't make sense. Maybe let's flip them.
Do they need to be local?
No, they don't need to be local. So much now is handled electronically, over the phone, via email, fax, that really there's no reason that they have to be local. I do recommend for the medical power of attorney that if we have a good option that's closer in proximity, that the medical power of attorney might be local or more local. And that simply comes down to who's actually taking you to a doctor's appointment? Who's going to be the first person to arrive when you go to the hospital? So sometimes if you have someone more local for a medical power of attorney, that does kind of make sense. Oftentimes we talk about maybe splitting those. Let's say you do have 2 children and, George is great with making medical decisions, but Bob isn't. But Bob is great with financial, right? So maybe we name Bob on the durable power of attorney and we name George on the medical first. And then that way, neither one is really overwhelmed with everything. I don't recommend for people to name people jointly, especially where they have to act together jointly. Families think that it's going to be harmonious, and it rarely is. And quite frankly, financial institutions don't like it either. And I think that's back to so much now is done electronically that banks can't really track, was this transaction, did both of them click yes? Or did only one of them choose to set up auto pay for the bills? So banks really don't like seeing joint acting together.
Okay. Good point. I think often we just think, okay, you take care of all of this without giving a lot of thought. So think carefully about who you choose. And I know for those of you who've been to previous seminars, and it wasn't even just legal, but it's come up before about the importance of who do you name as power of attorney?
I talk a lot with my clients so on a durable power of attorney, there's the regular powers you give someone, and then there's these additional powers. So the ability to create a trust, the ability to create or change rights of survivorship or beneficiary designations, the ability to make gifts and even large-scale gifts. If you're going to give those powers, I usually talk to clients about, I would rather you give someone all the power in the world, but choose the right person to give the power to, because hopefully we never need those powers, right? And hopefully we're only using those powers for good. But what if we need one of those powers and we don't have it, right? Now you're back in my office or your child's in my office saying, hey, I got to get a guardianship over mama because we need to do a ladybird deed on our house because we applied for Medicaid, right? And I'm like, well, you can't do that without a guardianship because there's no gifting power in this power of attorney. So I lean towards all the power, but let's be really selective on the person.
And we begin to see, and it's going to spiral in just a minute when we go into some of these. So another reminder, I'm sure most of us know, but sometimes we need reminders. Our power of attorney, that ends upon death.
Yes, ma'am.
So, you say, oh, well, my son has my power of attorney. When I die, he can do everything. You got to go back to other instruments for that.
That's right.
But there are a couple ways we want to go here, but you mentioned specifically ladybird deed. I want to talk about transfer of property, or have you talk about it. We already mentioned that if it's in a trust, then usually it's, take a death certificate and everything is pretty clear after that. Talk about, you mentioned ladybird deed. What are other ways when, this property, my husband passed away, but my name's on the deed. He's leaving the property to me, so everything is fine. Is it, or do we need something else?
So most families will they jointly purchase property, and it's community property. And so a husband and wife purchase their home, husband dies, wife thinks, oh, my husband died, I now own this property. And that's just not necessarily the case. But let's say what we want to happen is husband and wife own this property. We want wife to continue to own 100% of the property when husband dies. And then ultimately we want the property to go to our children. So we can do a ladybird deed that says we both own this property. When the first of us dies, the remaining spouse continues to own the property. But when the second spouse dies, the property goes to the children. And that's all in a deed. The deed gets filed with deed records. and it can be changed, revoked, modified, amended. The house could be sold if they decide, you know what, we can't afford to live here anymore, we don't want to live here anymore, we want to move to assisted living, then they could sell the property, still maintain 100% of those proceeds from the sale of the property, even with a ladybird deed in place. Sometimes people have also heard of a transfer on death deed, which is very similar to a ladybird deed. The primary differences are that a transfer on death deed is a statutory deed, and a ladybird deed is by common law. So there's no statute that says a ladybird deed works. And then big differences between the two of them are going to be that a transfer on death deed cannot be signed by a power of attorney, but a ladybird deed can. And that's kind of the primary difference. A transfer on death deed can also have a couple layers of beneficiaries, and a ladybird deed doesn't. A ladybird deed just has the original owners and then the grantees.
Okay. You mentioned a situation where the person is essentially incapacitated, they need guardian, they need help.
Mm-hmm.
Explain, and this seems to be one of those crazy things that we have a hard time understanding, or at least who's been explaining it to me. Guardianship, what does that mean? When does it come into place? What do we do?
So typically with a guardianship, what has happened is someone didn't come to your seminar and they didn't take the action steps. And so
see, this is how you can avoid this. Thank you, Sarah.
And so now they maybe had a stroke, right? Oh, I'll get to it. And then they have an unexpected health event, right? And now they don't have capacity. Well, under the eyes of the law, once you turned 18, you're a fully functioning adult, right? And you can make all your own decisions. But because of the stroke, let's say, this person now no longer can manage their bank account. They're not paying their bills. They're not able to take care of those things that they always took care of. And so because there's nobody else on the accounts, right, and nobody has access to those funds, we need to gain access. Well, they can't sign a power of attorney at that point because they no longer have capacity to do it.
That's an important point.
Mm-hmm. And so we have to get a certified medical exam. So there's an appointment with a doctor. A doctor will certify that this person can no longer make these decisions. We apply to the court, so we're back in the courtroom. We apply to the court, and we go through the process to have someone legally declared incapacitated and appoint someone to make those decisions. There's two types of guardianship in Texas. So there's the guardianship of the estate. So that's setting up someone to manage the financial affairs. And then there's guardianship of the person, and that's setting someone up to take care of the day-to-day living. So where does this person live? Who do they interact with? What type of medical treatment do they get? Oftentimes, we need one or the other. Sometimes we need both. It really just depends on what documentation they do have or what access we do have to financial accounts. So for example, sometimes we have a durable power of attorney, but we don't have medical power of attorney, or we have a medical power of attorney, but now a person is refusing medical care, or they can't live at home anymore because it's not safe. And so we have to get a guardianship so they can get protective care.
So I think really I skipped a step here. I remember now that I wanted to ask, so just backtrack a tad. Medical directives, because this kind of is the gap in between or gets to there. What about, so I need to have my, advance directive. Tell us a little bit about that. What's going to happen to me? Am I going to be kept alive?
So I'm going to talk about the documents kind of in order of use.
Okay.
So the first one would be a HIPAA authorization. So all a HIPAA authorization does, and you've probably signed a bunch of these at the hospital or the doctor, says these people can get medical information. So they don't get to make any decisions about me, but they can call the doctor and find out, hey, my mom said she came and saw you, but I don't really understand what she's telling me about her new medication. So they can get medical information, but they're not making decisions. That's a HIPAA authorization. Next, you have a medical power of attorney. So that is, you're incapacitated, you cannot make your medical decisions anymore, and this person is appointed to make those decisions for you, right? So that might be because you had surgery. It might be because you now have dementia and can't make medical decisions. But for whatever reason, you're incapacitated and you need someone to make medical decisions for you. Then there's a directive to physicians. A directive to physicians is, I had a stroke, I'm maybe in a coma, and the hospital has decided I have a terminal or irreversible condition, and I am not expected to live longer than 6 months. All right? That's when we're using a directive to physicians. So the directive says, do I want to be on life support? Do I not want to be on life support? Do I want extraordinary measures taken to keep my body alive? All right, so that's kind of the third document. And then the fourth document that I get asked about, and that quite frankly, we just don't do that many of them. And this is a form. It's the an out of hospital, do not resuscitate. It's actually a form that even we downloaded off the internet. We get it off the Health and Human Services page because it has to be their form. And that is the one that says, if I get in a car wreck out here and I happen to have that document on me and the EMTs show up, don't resuscitate me, right? So it's different than a directive.
So on the DNR, and we hear that term a lot, and I know there have been a lot of discussions, well, I've done DNR, I now want to be resuscitated. But if that form is not readily available, it does, I mean, just like you said, if I'm in a car accident, maybe I just happen to have that form pinned on me today. It's not going to do any good if it's at home in my kitchen drawer.
So I know if you live in like assisted living or nursing home, oftentimes it's posted to your door because EMTs are instructed to look there. If you're in your own home, I believe you're supposed to put it on your refrigerator so the EMTs. Anytime I get an EMT or a paramedic as a client, I always ask them, just for my personal knowledge, do you follow a DNR? And overwhelmingly, I have been told that they almost always err on the side of resuscitation because they are not versed in, I know, right? They are not versed in whether the form was properly completed, and you're having to make such split decisions that they almost always err on the side of resuscitating and getting someone back to the hospital.
So we'll hear stories of people, and it sounds bad, complaining about that happening, but in this day and time, back to transparency and liability. So, but still, okay, but you know, when you talked about all these forms, how many of us have gone into the hospital for surgery or some procedure where they're going, okay, do you have these forms in place? Well, somewhere, well, let's do them. And you're not even paying attention to them. So, but this is, we set up before to have these things listed. Be prepared. Who can get information from your doctor? Who can make decisions on your behalf? And so on. So, okay, so we kind of covered that area. Another area you mentioned, Sarah, that's related to this, long-term care. And the reason I shake my head, it's always such a challenge, and it varies a lot. Our favorite word, depends. But this is an area you do a lot of work in. So enlighten us on this topic.
So if you are fortunate enough to have a long-term care insurance policy, especially a very old one that allows you to have kind of unlimited benefits, which I see fewer and fewer of those because the insurance companies, I think, were going bankrupt using them. My advice on those policies are, number one, know the terms of your policy, and number two, don't wait to use it. Use it as soon as you're able to use it.
Now, what can we use it on?
So it depends on the policy. So some of them have benefits for in-home care. Some of them have assisted living care. Some of them are nursing home only. Oftentimes, you can start with in-home, and then it can move to assisted, and then it can move to nursing home. And what I see is people didn't understand the terms of their policy, and so they wait and they paid, thousands of dollars, and they use them for 2 or 3 months because they really didn't understand the terms of the policy. So that's my first advice. If you have a long-term care insurance, make sure you understand the terms of the policy.
But it
If
definitely,
you don't,
but it definitely does not cover, what about independent living? No, that
No.
one we know is out.
correct.
You've got possibilities for the others. Depends
Yes.
on your policy.
So then if you are thinking, how am I going to pay for my care if I'm unable to stay home and provide for myself? So the first thing to know is that Medicaid has an in-home care program and it has nursing home program.
Okay, I want to clarify, because I saw a lot of people go, wait, and you're writing it down. So Medicaid, you're saying we do not have to be in a nursing home.
So
It can be in home
there
with
are
certain conditions.
with certain conditions. What Medicaid does not cover is assisted living. So I think of assisted living and memory care as more of a luxury versus in-home care and long-term care. Now, the rules are generally the same with a few differences for the in-home and the long-term care in a nursing home. But what you should know is that if you are getting Medicaid for in-home, we'll talk about it first because it'll be shorter. If you're getting in-home Medicaid, they only provide up to 50 hours a week, right? So you can do the math. That's not a full week. It's not around-the-clock care. So oftentimes it really only works if you live with someone else or it's a husband and wife. And the other thing you need to know is that there is a wait list to get in-home Medicaid. So you have to get on the wait list. And you can do that by calling the star 211, which is HHS customer care line, and you can get on the wait list for in-home Medicaid.
So that has nothing to do with getting on the wait list for for whoever's going to provide my care. That's a wait list to get
That is a
approved.
wait list to apply for the benefit. So you have to get on the wait list before you need the benefit. Because once you need the benefit, oftentimes it's kind of too late to wait out the wait list,
But
right?
you can't apply until you're almost going to need the benefits, right?
Well,
How
the
do you-
wait list often, so I know there are some elder law attorneys in Texas who anyone who comes to their office over the age of 65, they put them on the wait list. I don't think that's necessarily the best approach because to me that clutters the list. Because what happens is you get on the list, you come to the top of the list, and you tell HHS, I'm not ready, put me back on the list.
So
And then
they've
you
just
work your way through the
wasted time.
list, right? I do think if you get an early diagnosis of dementia, right? You have early onset and you're still really managing your own care and you're taking care of yourself, but you kind of see it coming, or maybe even Parkinson's. Or there's other conditions that you see it coming. Or maybe it's your spouse. Maybe you notice your spouse isn't doing so well. That might be the time to get on the list, because even if you come to the top of the list and you don't need the benefit yet, you're a lot closer to needing that benefit, right? Like we have a diagnosis now, we know it's coming. And so I would say at that time, it probably makes sense to get on the list. For nursing home Medicaid, there isn't a wait list. So like if you go to the nursing home today, you have to have been in the nursing home for 30 days before you can apply, because you have to establish that this is a long-term care need. But there isn't a wait list to apply other than that 30 days. So when I think about the test for Medicaid, I think about it as a 5-part test. You have to be in the nursing home for 30 days. It has to be medically necessary for you to be there. You have to be in a Medicaid-coded bed. You have to be asset qualified, and you have to be income qualified. If you don't meet all 5 parts of that test, you won't meet Medicaid requirements, all right? So I'm not going to talk a lot about the first 3 because those...
The last 2 that are...
Yep, the last 2 are typically where our office gets involved. So the first thing to know about nursing home Medicaid is there are different rules for different scenarios. So the rules apply differently if we have a married couple where one person is in the nursing home and one person is still living at home. There's a different set of rules for a single individual. And then there's a third set of rules for both spouses are in the nursing home. So make sure when you're talking to other people, and they're like, oh, we got Medicaid, it was a breeze, didn't do anything, didn't have to do anything, make sure that you're comparing apples to apples, because your scenario might actually be different than theirs, and the rules are different. But generally, if you're a single individual, you're not allowed to have more than $2,000 in countable assets, and countable is a real key word there, and your income can't be more than $2,928. Sorry, that's backwards. $2,829. If you are a married couple, then there's a range of assets that you're allowed to have, which is roughly $30,000 to $150,000, but then you have to spend half of your assets. And so that, again, looks different for different couples. And again, it's countable assets. And then
so countable assets would, okay, you're going there.
And then for the two people in the nursing home, they're either going to look at you as two single individuals, so you're each allowed $2,000, or a combined $3,000 for the two of you. And then the income requirements are the same for across the board for all individuals. Accountable asset. So it's easier to kind of talk about what is an exempt asset. So what is not countable. If you're a married couple, a house of any value, so your homestead. So if you lived on a house with 100 acres valued at $2 million and you're a married couple where one is still living out at the house, that's exempt. All right? If you're a single individual and your house is valued at less than $713,000, that house is exempt, right? You're allowed one vehicle of any value. So whether you have a 1995 Honda Accord that barely drives or a 2024 Porsche, that one vehicle is exempt. An IRA that is distributing required minimum distributions is exempt. The required minimum distributions are countable for income purposes, right? So you might be able to exempt a $300,000 IRA. We just have to count the income, the monthly income, towards your income limits, all right? If you have an IRA annuity, that is exempt. A life insurance policy with no cash value, a pre-need funeral policy, and burial spots are all exempt assets. So you can actually own quite a lot and still qualify for Medicaid. It really just is a matter of what's your mix of assets and what's your situation with your family. Are you still married? Are you single? And then how much do we need to do to kind of get you under the appropriate limits?
So that's the spin down?
And that's when people talk about spin down, that's what they're talking about. They're talking about how do we, there's kind of some general rules, and the biggest general rules for spin down is what you're trying to do is, can we convert a countable asset into a non-countable asset? If you can do that, for example, I have $20,000 in my bank account, but I don't yet have a pre-need burial policy. So I'm going to go down to my funeral home and I'm going to pay for my $15,000 funeral, and now I have $5,000 in countable asset. I still have an asset in this funeral policy, but it's a non-countable asset. And so that's just an example of how that works.
Okay. And I think some of us, because we don't pay attention to details, or we have all these rumors always floating around, spin down, I have to get rid of everything. So that was an important part about the exempt and then the countable, and plan ahead and have guidance on that.
That's right.
Okay, wow. Long-term care, and we talked about documents.
I think let's talk a little bit about probate avoidance,
please,
because it
okay.
does kind of go hand in hand with the Medicaid planning. So I get a lot of people who come into our office and say, I don't want the government to take my house. I need to go to a nursing home, but I don't want the government to take my house. And so what people are really talking about is the Medicaid Estate Recovery Program. So Medicaid is a state policy, state-run program. But the federal government says you have to have a Medicaid estate recovery program to get federal dollars for Medicaid. So what happens is your house is exempt. Remember I said your house up to a certain value is exempt. So when you start going down the Medicaid road, you want a ladybird deed or a transfer on death deed put on that house so that when you pass away, you don't have to probate that will that you have, because it is through the probate process that the state of Texas makes a claim against your estate for reimbursement.
Now, that's an important reason to, right there, so have a ladybird deed.
Yep.
It's the easiest way, probably.
Well, it's
now,
the primary way.
What if it's in a trust?
So a house is a countable asset if it's in a trust.
Oh.
So for some people, if we're, again, back to if we're doing pre-planning, for some people, we actually will put a house into a trust, knowing that if they go into a nursing home, they're going to have to come back and take the house out of the trust and put a ladybird deed on it. And the reason why is back to the spin down. So in the trust, let's say your assets are $50,000 and a house. And that's really all you have. That's countable. So we put the house in the trust, it's countable. I now have $500,000, because my house is $450,000. I now have $500,000 in countable assets. I'm a married couple. I know my husband has been diagnosed with Parkinson's, and at some point, I'm not going to be able to take care of him at home. So when he goes to the nursing home, he goes in April 2nd. I go back to Rainey and Rainey, and I say, hey, we need to pull the house out of the trust and put a ladybird deed on it. That is my spin down. I had $500,000 in countable assets when he entered the nursing home on April 1st. In April, what is today? The 11th? April 11th, I pull that house out of that trust. It is now an exempt asset. I now spent down from $500,000 in assets to $50,000 in assets, and I'm now qualified for Medicaid. And I didn't actually spend a dime.
Yeah. Wow. The other thing, I think, maybe we're getting beyond that, but it used to be Medicaid is only for people with low income. Well, I mean, it's because but look at if you understand.
So there are over 140 different Medicaid programs, which is one of the reasons I have a job. Because truly it's a lot to understand, right? It's a lot to think about on a daily basis. There's Medicare savings programs provided for Medicaid. There's children programs, there's adult programs, there's adults with disabilities. There's all kinds of Medicaid programs, and it's just a lot of information to wade through if you're not doing it on a daily basis.
It sounds like that. Okay, I want to open this up for questions from our attendees, but is there anything else that you want to make sure that you address or share?
I think we hit the high points.
I think you've done a great job. Okay, questions that people might have. Oh, our mic runners are getting in place. Here comes Josie Zamora with Care Partner to Caregiver, a great resource to know about, and Comfort Care Ash Bist with a home care and an amazing resource about a variety of topics. Okay, I saw a question there. It must be Reg. Yes.
I think you briefly mentioned VA benefits. Could you give us a short briefing on what those may be, and especially, in lieu of, or like long-term care and things like that?
Sure. So primarily the benefits that our office helps with is non-service connected disability, which will provide some pension, if you've ever heard of pension or aid and attendance. And so oftentimes it's a good way to stay at home longer if you can. And essentially what it does is it provides a stipend so that you can use your other income to pay for in-home care needs. And so you have to have been 90 days active duty, one of those days in a wartime period. And then there is an asset requirement. So again, it's right around 150,000 that's kind of the cap for it. But that's for a single or a married couple. And I just forgot what I was going to say.
But I think you've given some good information here. It's also a great segue for next month when we will be talking about the very popular topic, aging in place, and how some of this, and you just addressed that, the aid in attendance and for VA.
It really is a great option, especially for like staying home longer. What I was going to say is it actually will, you can use it towards assisted living. So if you're looking to take that bridge from being in your home, but you don't really need nursing home yet, assisted living is something that can be used because essentially all of your income will be eaten up paying for assisted living. And so it's a great supplement for someone who goes to assisted living if they qualify.
Okay. Josie said there was a question. Oh, okay, Rita.
Thank you so much for being here. My question is, if I die, does my will have to be probated in the county in which I am residing, even if, say, I'm somewhere else for an extended period of time? Does it really matter the length of time I've been living somewhere?
So a little bit of that kind of depends on what you establish as your residency. So if let's say you live in Williamson County and you have a home here in Williamson County, but you move to Denton County, and you're in assisted living in Denton County because your children live up there. You probably, or whoever your executor is, probably has a little bit of choice of venue to decide, do they want to probate in Williamson or do they want to probate in Denton? Now, if you were visiting your child for Christmas, let's say, and you pass away, then it really should be Williamson County.
Okay, did that get your question, Rita? Let's see, Mike, I want to go back to Mike Carden, get Josie to run here. Mike, raise your hand. Okay, not Mark. Okay, next we'll get to Mike. Okay, right here. That's okay, go ahead.
Me? You're pointing at me?
Yes.
Okay, thanks. And thanks for being here, too. What is a disposition of remains? You mentioned that earlier on, and then I've got a couple other questions. Should I wait or just go for that one?
You can give me all your questions and I can answer
The other
them.
questions, are probate costs determined by the value of the assets in the estate, or does Texas always take part of the assets in a probate?
So the first question is, what is a designation of agent for disposition of remains? And it is exactly what that really wordy title sounds like. It is designating someone to be in charge of what happens to your body after you die. So for most people, if they don't have one, it's going to be the spouse first and then a child second. That's the order. But let's say you're a blended family and you don't want your new wife to make those decisions. You want your eldest child to make that decision because you really want to be buried on the family plot, right? You might designate your child because technically your wife has priority. Or I can give you a really funny example. I have a client who has very specific requirements for what he wants to have happen when he dies. He wants to be cremated. He wants there to be no music or karaoke of any type played at the memorial. He then gave them the option that they were allowed to take his ashes out to Terra Cemetery and dump them there. Or alternatively, he wanted his ashes out the window while driving south on I-35, going over 75 miles an hour. This is an actual document that I have drafted. And so he had very specific requirements, and he designated his daughter to make sure that that happened when he died.
And you might want to warn the highway patrol while
Yes.
you're...
Because I'm not actually sure it's legal to do that.
Oh, wow, okay.
And then
yeah.
to answer your other question, so the probate question, so there are instances where there are contingent fee, I think that's really what you're asking about, where there are contingent fee agreements for probate. Oftentimes, I think that comes up more in a contested probate matter. That is a standard in other states, like that's why California probate is extremely expensive, because most of the time it is a contingent fee basis, so the attorney will take 30% of the assets. But there isn't I think you asked if Texas has a requirement, is that right?
Well, do they always take part of the assets, or are there sometimes where Texas gets left out?
Like in a Medicaid context or in any probate?
Well, in any kind of, in a probate,
No.
I don't understand.
There's no Texas estate taxes, if that's what you're asking. There's no Texas estate taxes. And the only reason I could think of is if you had some sort of judgment that Texas had filed. I mean, in a Medicaid context, they're a creditor of the estate, just like a credit card company or something along those lines.
I had one other question.
Sure.
And that is, what is a living will?
Living will is a directive to physicians. It's the same document.
Okay, yeah, Mike.
You talked about having joint powers of attorney or executors as a bad idea, but in the circumstance that the person I've named and given my power of attorney, or I've named my executor, if that person cannot act for whatever reason, he died in the same car wreck that I died in, now what happens? Can I name a contingent POA and executor? Would that be advisable?
Sure. We oftentimes name 2 or 3 kind of lines of defense, right? So I'll have my husband first, my mom second, and maybe my sister third, right? I don't have any adult children, so that would be my order. Absolutely. I even, for example, on my parents' documents, it actually, for my dad, it has my mom or Sarah, right? So it has my mom or me can act, which is fine because it's either or, right? So we're actually, the or is key. What I was advising against is Rose and Sarah to act, because now you need both of our signatures on everything. And the only thing I caution you with if you do that or is, are Rose and I going behind each other, and now we're getting a guardianship because the 2 agents that have been appointed are on top of each other making changes, and that's a problem.
But if you have a designated order.
Yes, so Rose first, then Sarah, then Catherine.
Let's see, other questions. Okay, let's go, right over here. Don. Okay, and then we'll come up here to a question. Okay, Don?
You talked about a married couple. What are the ramifications of a couple who live together but are not married?
You are not married. You are single.
True confession. Oh, you're saying that in terms, okay, but in terms of property, it's community.
Like, is that what you're asking me? Like, if you own the house together?
That's covered by the...
Please have a will.
Because in Texas...
Truly. So let me give you a perfect example. I am dealing with a client right now who purchased a house in 1995 with a man. They weren't married. He had children. She had children. They have no children together. He died in 1996. Nothing was done. No probate, no nothing. Fast forward to 22. She died. My client is one of the children of the woman, and they want to sell the house. Except I can't get the children of the man to participate. And so now we are suing them for partition because I can't get them to act together because there were no wills. I've got essential strangers who now own a house together, and they won't play ball together. Have a will.
The whole thing, too, about the will and who's in charge, you made me think. I went through a situation with a family. This was just 4 children, same children from husband and wife, who couldn't agree. Mm-hmm. And we were just, it was a mess, so we had to have a court-appointed administrator to take care of this, and it just, and the other thing, there are
And it's more
pieces,
expensive.
and you got more money.
You then get to pay someone to handle what they should have been doing together.
So
And
hope
so
you
they
have-
get less money out of the estate.
Right, hope you have a harmonious family. I think, oh, did we get them? Okay. Wait, where is the mic? Oh, it's back there. Okay, Ash, could you bring the mic up here?
Yeah.
And then
And then we
while,
can take that gentleman.
yeah, we'll take back there. Ash?
Yes, right here.
Thank you.
Thank you for being here. 2 questions. If you had a client and there was no one in the family or friend who would be the secondary person in all of the documents, but specifically in the will, or if you were doing a trust, what would you recommend there?
So typically, my recommendation for like a will or a trust is going to be to name a financial institution. So a bank, a trust company, something like that.
Okay, second question. If you are in, and I can name it if you want me to, but if you're in with a financial institution that is managing your assets, and they offer the services of a trust, and you're an independent lawyer, would you recommend that you not do that, but do it with an independent lawyer?
Like, are they offering to draft the documents or just to serve as the trustee?
Can I say Schwab? I
Sure.
just did. Okay, so a part of their
No.
yeah, a part of their services for me is they're not going to do it, but they're going to offer it as a service.
So they probably have a connection with.
Sure, they have an attorney they're going to send you to. I mean, on the one hand, I don't really know how to answer that question. I guess what I would say is just make sure you're kind of really reading those documents to make sure they're advantageous to you. But also, I'm going to say that in some ways, I could see where that would be beneficial if that's who you would choose anyway, because you're going to know that the documents are drafted in a way that kind of comports with their protocols.
All right, let's come up here. Thanks, James.
Okay, if your assets are more than Medicaid accepts, is there anything from Medicare for nursing home or medical attention?
So Medicare pays for rehab in skilled facilities. So they pay for the first 20 days in rehab and then up to 100 days. But that is for rehab services. That is not for long-term care.
So nothing for long-term?
No, ma'am.
Yeah, right over here.
Oh, I have the mic.
Oh.
I have the mic
Okay,
right here. I just wanted to know if the spouse dies and the home deed is in both names, should I change it before the thought of selling?
Yes.
Okay, some of us couldn't quite understand.
Sure. So she asked if if she owned a house with her spouse and that her spouse has passed away, should she change the deed into just her name prior to selling? That was the question, right? And so, yes, I would say if you're thinking about selling, you should go through the process of getting that all into your own name. If it's a one marriage, one set of kids, you probably are able to do an affidavit of heirship. So it's not as intense. You'd have to look at the documents to know if that's the real route to go. But I would say if you started it on the front end, it would just make the closing process a little smoother. Don't you agree?
Absolutely. And that's when people, the rumor is often, oh, well, okay, I'm going to list my house and I can just go do this and it'll just be done. Well, it may or it may not, from what I'm understanding. If it's one marriage and very, straightforward, that works. But we have a lot of blended marriages, blended families, and they can get complicated.
Well, and the thing to know there too is you have 4 years from the date of death to probate a will.
Yes.
And then the other thing that happens, so back to my kind of example of earlier, the man who died in 1998, if we're doing an affidavit of heirship, finding someone who knew him well enough to know who he was married to and who his children are to do an affidavit of heirship becomes difficult because he's been gone for, almost 30 years. And he was elderly in the 90s. So, that becomes a problem too.
Because I've seen that where we're listing a home and someone says, okay, yeah, it's the will, it's mine, and her name is on the tax record, so I think we are fine. But then we find out no, and then we have to do the heirship of affidavit and so on. Okay, let's see. We saw, okay, back, yeah.
Yes.
And then we'll come up here. Okay.
Could you tell us again how you could put someone on the in-home Medicaid list, the number to call?
211. It's
Just
star
from your-
211.
From your landline phone, you just do star 211?
Anything.
I think any phone, it will take you there. Yep.
Okay, and so another, let's see, oh, my lots of, okay, right there, and then somebody over here. Okay.
If I have, my executor is out of state, is it better to have a will or a trust? All of my documents are Texas, but he's not.
That isn't necessarily a reason to have a trust. It maybe makes it slightly easier for him when you pass away.
Let's come over here.
You can have an out-of-state executor. He will just need a resident agent. So he'll need someone in Texas to accept service of process. So he just will have an additional step if we're probating your will.
Yeah, so does that make sense, Melinda? I understand why you're asking that. So, okay. All right. I want to come over here because Mike's asked a question, then we'll come back here. Right over here. There you go.
Yes. 30 years ago, I bought long-term health care insurance, thinking that was very wise. It started out about $4,000 a year, and they had certain benefits. Well, recently, they have decreased the benefits and increased the cost, like
Sounds right.
three times as much. So, and I get a list of choices, and one of them, they're going to increase the cost by 1,300%.
Sure.
And at what point? I mean, that's one. It's kind of it's not a good deal that I found out. And the second, at what point somebody can look at this and say, forget it all, or they do give up money back. But
So, I mean, oftentimes, when I'm talking to clients about exactly what you're talking about, the first question is, can you afford it, right? Like, can you afford to eat and maintain this long-term care policy? Because obviously that comes into play. And then the other thing, too, I would really look at is, what is the benefit? Like, do you fully understand what the terms of that policy are? And how close do you feel like you are to being able to actually use the policy? Because oftentimes I find my clients maybe don't have enough humility to say, I actually could use this now. I actually could get a doctor to certify that I can't do 2 or 3 activities of daily living. Because, we sometimes need more help than we're willing to admit. And so I also advise clients, like, really take stock of how close are you to, like, needing some in-home care where you could use this policy? Because I see so often people have these great policies and they never use them, or they wait and then they get a very little benefit for the amount of money that they've paid. And if you're not getting any of those funds back, then you're making that kind of cost analysis of, is it better to keep paying, or is it better to just call it a sunk cost and move on, right?
So, because that is, in a way, a general question too, but we're going to try to, we probably have time for just maybe, okay, I promised Mike,
Yes,
and then we'll go back there, and that will probably be it. Mike?
Another great reason to have a will is a little thing called a life estate. My sister died intestate. Her husband, a second husband, who married her after she had already bought and acquired this home, they were only married 18 months and she died. Fast forward 25 years, her children then wanted to sell the house. The house had been rented all this time. He shows up and says, oh yeah, half of that's my house. And now there's no will describing his ownership of the thing. It took a lot of work to unravel that because he claimed his right of life estate. He never paid a bill on the house, anything. He didn't participate in the ownership of the house except to wait until the daughters wanted to sell the house.
That dying intestate can be very problematic.
Yes.
You might explain what a life estate means, because probably there's other people in this room who will be caught in that.
So the state of Texas Constitution gives a life estate to a spouse for a homestead. So that's a Texas constitutional right of a spouse to have a life estate, which means kind of what you described. It was her separate property, and he was able to live there till his death. There's a little bit something suspicious, though, about your scenario, because it actually sounds to me like he abandoned the property, in which case he shouldn't have been able to claim a life estate if he had abandoned it. So I don't want to get into to probably what y'all went through, and it could be a timing based on some of the laws and case laws that have happened with relation to life estate.